Lady Milords, I do apologize. I did say that I'm going to address you on the facts, but I need to clarify one point that I made in my opening submissions on law, and then just deal with one further point that Miller and Trent made, and we'll then turn to the facts. The first point concerns the question that you raised about appendix continuous residence. So we now have a copy of that appendix. Grateful to Miller and Trent. Just hand it up. So you'll see that under this appendix, all that an applicant is required to do is to be in the UK for 6 months in 1 year. So it's possible for an applicant to be absent for 6 months. So that, in my submission, is not inconsistent with the submissions that I made as to the effect of ROB 16.1. So it's possible for an ROB to establish a company, return to the country of origin, but keep visiting the UK for 6 months or so, or keep visiting the country of origin for 6 months or so. And after 5 years, they will qualify for indefinite leave to remain. There's no requirement for them to work for the business or run the business in the UK, as long as they are employed by and working for the parent company, they would meet the requirement. Grateful. Secondly, I showed you, of course, a part of the Secretary of State's published policy. It wasn't my intention to raise a new ground based on the policy for the first time. And I have accepted that this policy would not apply to ROB 8.2. Just want to clarify that I'm not making a new point about a policy. Therefore, I'm content for the court to just leave the policy to one side and decide the appeal on the basis of the case law and the authorities that are before you. Milady asked a question that the two authorities that I showed the court, Anjum and Mushtaq, must be read in conjunction with Taj, the authority that Miller and Trent has taken you to. And I have made a point about Taj as to the interview that was conducted in that case, and I've taken you to the judgment of Lord Justice Green concerning that interview. There's one further point, which is that it is absolutely clear, in my submission, crystal clear, that Taj is an authority about the points-based system. This is what Lord Justice Green said at the outset, at paragraph 1, that this appeal was about the principle of procedural fairness to a points-based system application. And everything that he said in the judgment itself concerns the points-based system and the scheme of that system. But this appeal is not about the points-based system. ROB application is not a points-based system application. Points-based system is in part 6A of the immigration rules. This is a completely different category. It falls outside the points-based system.
Is part 6, which is the point-based system, is that gradually being phased out, or does that still exist in parallel with provisions like this?
Well,
forgive my ignorance, I just don't know the answer.
No.
So I'm asking an expert.
No. So what I headed up, the Tier 1 entrepreneur rules, they are from part 6 of the immigration rules. And that part still stands. Right. And of course, it's now quite restricted, given that there are now other provisions in the rules, other appendixes, other parts that deal with these sort of applications.
So is the points-based system sort of gradually withering away? Is that?
It is, yes. So you don't score points anymore.
No.
So the scheme of the points-based system essentially was that if you have X, you will get X points.
Yeah,
If you have
yeah.
Y, you will get Y points. And the criteria was crystal clear, entirely objective.
Sure.
But this, I emphasize with respect, is not a points-based system application.
No.
Now, the authority that is on fairness in a case that is not about the points-based system case is the judgment in Karagul, the judgment that I cited in my skeleton. That's behind tab 8 of the authorities bundle. So you'll see that that was an application where a judicial review claim that concerned a refusal of an application for leave to remain as a business person under the Ankara Agreement and the additional protocol. And the application was refused on the basis, this is paragraph 10 of the judgment, that the decision maker was not satisfied, that it was the genuine wish of the applicant to establish the proposed business, or it was their genuine intention to establish the business. The key ground was procedural fairness. Mr. Justice Saini, at paragraphs 95 onwards, reconciles all earlier authorities on the subject, starting from Doody, Citizens UK, Balaji Gari, and Al-Fayed. And if you wish to see a summary of the conclusions in 3 points, that is paragraph 103. So at paragraph 103, the judge summarizes 3 principles, and I respectfully invite the court to endorse those principles. Where a public authority proposes to make a decision that the applicant, for some right or benefit or status, may have been dishonest in their application, or has otherwise acted in bad faith or disreputably in relation to an application, common law fairness will generally require the following safeguards to be observed. Chance to address the concern in an interview, or are minded to refuse written process. That applies in particular given that there is now no right of appeal against decisions of this sort. And availability of administrative review is not an answer to this point. This is really what more or less the policy itself says. So in this particular case, lady and lords, you will look at the interview and you will decide whether the interview was a fair interview. May I now turn to the facts and just take you to the interview first. Page 98 of the bundle. And what I would respectfully invite lady and lords to do is to read this interview in due course in full. When you will read this interview in full, in my submission, you will come to the conclusion that many questions were unfair, and the answers that the applicant gave to every single question, including the unfair questions, were rational and perfect answers. I'll simply highlight a few questions for you, the questions that were focus of the Upper Tribunal's reasoning. And the judge's concern, one of the concern was that it seemed that the wrong template was used. It's quite clear that the interviewing officer was using a template. And the questions were already set. If you look at question 5, did you have any help in completing your business plan? Your business plan. So when I showed you tier 1 entrepreneur rules, a tier 1 entrepreneur applicant is required to have his or her business plan. And you would see this sort of question when the decision maker is deciding that sort of application. There is no question of the applicant producing her business plan in this case. And her answer was perfect, that, well, this isn't my plan. Question 9, what sort of business?
Go to 9.
Yes.
You say this is clearly a template. But that's right, the template included at 8 a reference to the Overseas Business Representative Group.
It is, yeah.
So why wouldn't that be an appropriate template to use?
Yeah. Of course, there are references to questions relating to that route, but the point that the Upper Tribunal made is that when you will read the interview as a whole, it may be that there are 1 or 2 questions that are on point, but reading the interview as a whole, one gets the impression that the decision maker had wrong test in mind.
And I follow the argument, but if you're right that there's a template, the template surely must be designed to deal with the Overseas Business Representative route when that's there in the question.
Now, when I said that there is a template, I mean it is entirely legitimate to use a template. I mean even to use a tier 1 entrepreneur template in an ROB application, as long as the interviewing officer asks the right questions, there is probing and investigation and appropriate modification. And the ultimate question for my lords is whether this is surely a template, whether this template, when you read the interview as a whole, whether it was a fair interview. That's how I, in my respective submission, that's how I put my case.
On the same track, question 21, your selection as the overseas representative is plainly relevant to the
it is
that we're looking at.
Yes. Yeah. Yes.
And 20 is not a template question. 20 is specific to this case.
Yes. So you absolutely, my lord, you're absolutely right that one can pick a few questions, a few answers relating to the route in question, but predominantly, it's entirely a question for my lords and my lady, predominantly what the interview tells us, whether it was a fair interview.
Sorry, can I just be clear, Mr. Malik? Are you maintaining your point that the wrong template was used, or are you abandoning that point?
No, I'm not making a point, milady, that you dismiss the appeal simply because the wrong template was used. No.
It's my fault for not being clear, Mr. Malik. Are you maintaining the submission that the wrong template was used here? Just want to understand what your position is, please.
No, I'm not. I'll not make a point about template now.
All right, thank you.
Great, thank you. Grateful. So, question 9. What sort of business do you intend to set up in the UK? And can you describe what your business idea is? And you'll see the answer to that question. And the answer with respect is an entirely rational answer. Question 13, how much do you intend to charge for your products and services? Just picking the questions that that anti-clearance officer ultimately picked, and the questions that were picked by the Upper Tribunal. Again, entirely rational answer that we haven't prepared a budget at all, because the idea is, for me, the applicant says, to go to the UK to study the market and demands, to report back to the management, and that would then facilitate a branch opening.
That suggests it's a research trip rather than a branch. It's a precursor to a visit for the purposes of establishing a branch.
No, the question, milady, was that well, how much they intend to charge for products and services, and that was the answer to that question. So the question that milady has asked, again, with respect, it is a valid question, but there was no follow-up question, milady, we'll see, so far as that point is concerned. The interviewing officer could have probed the answer further, could have asked, well, that essentially means that you're going to the UK for research rather than for setting up a business. What do you say about that? And the applicant would have answered.
If you're turning the page, and though this won't matter at all, can I just understand, back at question 11, what does RQ 73.7% shares mean?
RQ is, I don't know the answer. I've just asked my sister to confirm.
RQ seems to come in front of quite a lot of, but not all the answers.
Response to the question?
Sorry, yes. Yes, so RQ means repeat question. Malevolent says.
Oh, I see, so it means the interviewer has repeated the question, has asked the question once, and then repeated it.
Yes, and then, yes,
and
that
then
appears to be.
elicits a further response.
Yes, so yes, precisely.
Right, okay.
Yes,
Right, thank you.
73.7 shares.
Yeah, it's not immediately obvious.
No,
Is it? Unless you're well versed in the code. Okay.
Yeah.
What is your recruitment plan? Question 16. That will be set up by the company management. And the applicant then explains that I will be alone as a sole representative. And once the office facilities will be set up in place, then management will decide to recruit more employees. We'll employ local managers to run the business. The task of the applicant is simply, in my respective submission, to set up the business. The address, the applicant says, question 17, probably in center of London, but it is the management that would choose the location. She then explains question 18, why she was chosen, because of the past experience, seniority within PAL, years of service, job description, so on and so forth. And then you have question 20, the question that was picked by the anti-clearance officer. A question was asked as to why establish the branch in UK as opposed to Germany and France. She said UK is nearer to Bangladesh. It's arguably not clear. What in my submission the applicant really meant is that there is less of a cultural difference between the UK and Bangladesh as compared to between Germany and Bangladesh or France or Bangladesh. But there could have been, again, I say, it could have been a follow-up question, further probing, that you say that UK is nearer to Bangladesh. What do you mean by that? You make a point about the time difference, but what precisely you have in mind? Mullen Friend says that the actual requirement of the rule is that you demonstrate that you are able to set up and run a business Now, this is not, as I have respectfully submitted, this is not what the rules actually require. But if the rules actually require that, then why not ask that question? Why not ask, well, how will you run the business? How will you supervise the business? So the purpose of this interview was to probe and investigate, but also to give a fair opportunity to the applicant to respond to potentially adverse matters, things that were troubling the decision maker. Those matters were not clearly put to the applicant. The interview ends, page 103. The entry clearance officer, before saying thank you to the applicant, says that the entry clearance officer will now make a decision whether or not you are a genuine entrepreneur. True it is that there are one or two questions relating to ROB route, but predominantly in my respective submission, there is at least substantial doubt that the entry clearance officer had the wrong test in mind. On the next page, page 104, you have the decision letter. It's elsewhere in the bundle as well. If you then look at that decision, if you have marked the copy that Mullen Friend took you to, then that copy, I think, is at page 147. So it's 104 or 147. So the decision maker refers firstly to ROB 5.2. This is the genuineness requirement. The concern is that the applicant is not a genuine applicant. And there is some sort of conspiracy. The business is creating this route mainly to enable the applicant to apply for entry clearance. Surely an allegation that a concern that the applicant and the business are acting disreputably. Well, why not put this to the applicant? Say that, well, I have concern that you're not a genuine applicant. What is your response to that? That is what, in my submission, fairness would require. And then the decision maker quotes ROB 8.2. Why not ask the question, well, are you a senior employee? Why so? Well, tell us about your skills and experience and knowledge that would enable you to undertake the role. And do you have full authority to negotiate and take operational decisions on behalf of the business?
There was something about that there, wasn't there?
Yes. And
question 21.
And question 15.
so 15 is, well, what is your relevant experience, education for the role? And then question 21 is about the selection. But my point...
And just take 21, and the second answer, I'm a senior person because I report directly, and it says I given, must be I had been given
Yes.
the authority to take operational decisions.
Yes. So when you look at the decision, and can I just take you back to the decision? So there is no dispute that the applicant is a senior employee. The Upper Tribunal recorded that fact, that is not challenged. Nowhere in this decision, the entry clearance officer says, unless I've missed something, that the applicant does not have full authority to negotiate and take operational decisions. What the decision maker does is that they pick 4 or 5 questions and answers. And if you look at the first point that is made is about the business plan. This is page 147, second last paragraph. As part of your application process, you were asked if you had any help while completing the business plan. You responded no. And then there is a question and answer about charging of the products and budget. On the next page, you'll see the answer. And then paragraph 3 at page 148, you'll see a question about the base for the business and the answer. 4 questions and answers are quoted. And then you have the 2 paragraphs with the reasons. Paragraph 4, when asked for basic information that a genuine candidate should be able to answer, you were unable to provide information on where you plan to base the business, as you do not have location to pick. ... By your own admission, you did not have a hand in creating the proposed business plan. She cannot have the hand in creating the business plan. It's not her business. And the whole idea is that you can only appoint someone as a representative if they are not a shareholder or a director. If she had created a business plan or had a hand in the business plan, that would have justified a refusal on another basis. And the business plan was obviously prepared by the parent company. There's nothing in my respective submission in that paragraph that justifies a refusal under ROB 5.2 or 8.2. And then you have a question about UK being nearer to Bangladesh. And then a conclusion that this is incorrect and you do not have required skills or knowledge to be able to open and run a new branch. That's not what the rules require. The rules require you to have full authority to negotiate and take operational decisions. So there is, in my submission, no real correlation between the rules and these reasons.
Isn't it implicit in having authority to negotiate and take operational decisions that the representative will be negotiating and taking operational decisions? Because what's the point of having authority to do those things unless you're expected yourself to do them?
Yeah, I mean, in my well, two answers I think that I can legitimately give. The first is that, lady, again, this isn't the point that the decision maker made, at least in this decision. Secondly, it is certainly possible for a supervisor or someone supervising the business to have authority to negotiate and take operational decisions, but let the managers run the business and to take forward the negotiations and implement the operational decisions. There is, in my submission, a distinction there. very quickly, if I then just show you the Upper Tribunal's reasoning as to grounds 3 and 4. So if you go to page 41 of the bundle, paragraph 51, the judge's reasoning as to those grounds would start. The first point the judge made, it was one that was conceded by my learned friend, that there is no specific reasoning as to ROB 5.2. That, in my submission, is enough to impugn the decision on that basis. You've got to give reasons as to why you believe that an applicant is not a genuine applicant.
And just to be clear, when you say impugn the decision, you mean the 5.2 aspect or all of it?
The 5.2 aspect of the decision, yes. And then the judge says, and I take no issue with that, that a written minded to refuse process was not necessary. But where there was applicant, there was an interview, you got to put the concerns clearly in the interview. There is then a discussion of the various authorities, Penkmalat, Balajigari, and Karagul in particular, 103, the judgment to which I've taken you to. There's no reference, of course, to Taj because said this isn't a Taj territory at all. And then to Anjum, again, the authority that I took you to, that interview must be fair. And then paragraph 55, the judge identified certain questions from the interview. And the finding that the judge made at the end of paragraph 55 is the correct finding. And this isn't inconsistent with the points that my lords were putting to me, that there are some questions that are relevant to ROB route. But if one looks at the interview as a whole, the questions were unfair and they were focused on a different test. Individually, the questions may not transgressed, but if you look at them together, they would disclose a flawed approach. And then the last sentence, and that's why I invite you to read the interview in full. The answers given in the interview were entirely rational. When you look at the answers, you'll see that there couldn't have been better answers for an application of this type. The judge then correctly refers to the concluding part of the interview. And then at 57, at the end of paragraph 57 says, applying the Porter test, that there is substantial doubt that the entry clearance officer applied the rules correctly. That was all that was needed to succeed on that particular aspect of the ground.
And just there's substantial doubt that the decision maker applied the correct rule in the decision letter.
Yes. Yes. So if the reasons given in the decision letter give rise to substantial doubt that the rules are not applied correctly, then the claim succeeds on the basis that the reasons are inadequate. That, of course, I emphasize with respect, is distinct from the point about fairness that I've made. Paragraph 59, it wasn't clear, the judge said, as to what the decision maker meant when they said incorrect to the question about UK being nearer to Bangladesh and about the time. The judge repeats the point that there is no reasoning, none whatsoever, as to ROB 5.2. And again, a substantial doubt whether the ECO understood the important matter of the immigration rules or was applying them and thus reaching a rational decision on the relevant grounds. Lady Lords, grateful for your patience. Unless I can assist you any further, for these reasons, I invite you to dismiss the appeal and uphold the ultimate decision that the judge has made.
I can't see any further questions, so thank you very much, Mr. Malik. Mr. Biggs.
Thank you very much, my lord. Just a very small number of points in reply. Firstly, just a minor point about the way my own friend expressed himself. I think at one point he said that the decision letter, page 105, for the relevant text, said establish and run. It actually says open and run. I'm not sure a huge amount turns on that, but it's of course our case that in this context, the words open and run in the decision letter reflect the correct legal meaning of establishing a branch in Appendix ROB. And so it may not be entirely insignificant, but there's a different formulation there. We want to make clear that our position is that the word supervise in Rule 4.4a is in the instant context essentially no different than running once the context is properly understood. Because a sole representative who is in charge or is supervising the branch in the UK, in the sense that they are responsible for the operation of the branch, can naturally be said to be running the branch. And my learned friend rightly accepted during the colloquy earlier that the rules use synonyms and that the relevant rules in respect of entrepreneurs at paragraph 245D and following use the synonyms operate and run. So in this context, the word supervise is essentially synonymous for run. But in any case, I repeat the point I made earlier for the sake of clarity, that it's wrong to adopt too exacting a standard in respect of review of the language used in the decision-making in this case. The decision-makers in this case were not lawyers, obviously. They were simply seeking to encapsulate the substance of the rules. And in my submission, that's what they did. My learned friend says that paragraph ROB 4.4a of Appendix ROB is of no relevance in this case. He says that that's so because the decision makers did not specifically rely upon paragraph 4.4a. But that, in my respectful submission, mischaracterises the Secretary of State's case in this regard. Paragraph 4.4a is plainly relevant to the interpretation of the words establishing a branch in the opening text of Appendix ROB. And to suggest otherwise, as I think my learned friend must, is simply contrary to paragraphs 27 to 28 of the Mahad decision that my learned friend took you to earlier and placed considerable emphasis on. If the context of the immigration rules is relevant, as it plainly is, then the passage, the text of 4.4a is of very substantial importance.
It informs the meaning of the question.
Yes. My learned friend relies upon, for the first time, paragraph 16.1b of paragraph of Appendix ROB to suggest that a representative of an overseas business might be able to supervise a branch remotely from abroad, so as still to be eligible for a grant of indefinite leave to remain for settlement. That is a surprising submission with great respect, and it is clearly wrong. If we turn to the text of ROB 16.1, Page 11 is using electronic stuff for everyone. Page 11 of the authorities, line tab 1. Applicant must have been employed and working full-time for the overseas business, etc., or for that business's UK branch or subsidiary. What this rule is doing is it's making clear that the representative has to be employed by the overseas business or the branch or the subsidiary. There's nothing in that rule that suggests that it's appropriate under this scheme for the representative to attempt to discharge their responsibilities as a sole representative of the overseas business from outside the UK. And indeed, it needs to be borne in mind that in this case, the first respondent was employed by the overseas business. So she was going to be employed by them in the UK, but the rules make clear, ROB 4.3, ROB 4.4a, that she must be working full-time and exclusively as the supervisor of the branch of the overseas business, and that branch must, this is the last part of 4.4a, trade in the business of the overseas business in the UK. I asked rhetorically how all of that can be done if the applicant for indefinite leave is outside the UK. And of course, it's right to note, as the court put to my learned friend, that my learned friend's submission by reference to 16.1b is very hard to square with ROB 15.1. My learned friend points to the possibility that a person can meet the requirements of appendix continuous residence by spending no more than 6 months or 180 days outside the United Kingdom in any 12-month period. But that doesn't help him, because it's quite clear that appendix continuous residence requires a person to be primarily resident in the United Kingdom. So that, if anything, points against my learned friend's surprising argument by reference to ROB 16.1b. Finally, on this topic, I would just draw attention to ROB 16.3. The applicant must be required by their employer to continue in the role for which their last period of commission was granted. And the expression the role then suits us back to establishing a business, establishing a branch, in paragraphs 4.4 and 4.3. This on analysis just provides no assistance at all to my own friend. Moving on, I also note that my learned friend's concession that it is rational for the purposes of applying Rule 4.4a of Appendix RFB to have regard to knowledge about the UK market. My learned friend's concession in that regard is very difficult to square with his construction of ROB 8.2. If a decision maker can take account of the fact that an applicant doesn't know much about the UK market for the purposes of the evaluation required by 4.4a, why not? Why would the decision maker not also be able to take that information into account when applying the second element of ROB 8.2, the skills, experience and knowledge requirement? With respect, that strongly indicates that my learned friend's construction of ROB 8.2 is absurd. My learned friend, as I expected him to, placed considerable reliance upon paragraph 245d and the subsequent paragraphs dealing with entrepreneurs. The short point here is that my learned friend has put just too much weight on that point. There may be good reasons why rules are expressed differently. It's already been accepted by my learned friend that immigration rules can sometimes use synonymous terms. But in any event, my learned friend has not answered my submission on this point, paragraph 29 of our skeleton argument, page 207 of the bundle, which is that the relevant rules that my learned friend draws attention to cover both cases where someone is seeking to establish a new business and cases where the business is already established and they want to continue to work for it. So there's good reason in that context why that particular formulation might be used. It just doesn't assist my learned friend in this case. On procedural unfairness and my learned friend's reliance on Mushtaq and Anjum, my submission is that those cases now must be read in the light of the Taj decision. Both Mushtaq and Anjum were PBS cases, points-based system cases. And they're not entirely easy to reconcile with Taj, but in any event, Taj sets out the correct legal principles, certainly in points-based system cases. And as I accepted in opening, this is not a points-based system case, but the reasoning in Taj, bearing in mind the nature and terms of Appendix ROB, is significantly analogous. So in the light of the Taj decision, in my submission, there was plainly no unfairness in this case. My learned friend's reliance on Carable, paragraph 103, is misplaced. This is not a case where there is any imputation of dishonesty or disreputable conduct. And the Upper Tribunal, in fact, specifically rejected the argument put by my learned friend that a Balajigari minded to type process had to be followed in the instant context. And the Upper Tribunal was right to reach that conclusion. So there is no need to specifically endorse paragraph 103 of Carable. The point doesn't assist my learned friend. And with respect, we would urge the court not to do that. There's just no need to get into that territory, which may be contentious for a future case. Turning to the policy document, my learned friend has clarified that he doesn't rely on the policy document directly, but to be clear, the Secretary of State does not accept that the text on page 14 of the policy that my learned friend drew attention to reflects the requirements of procedural fairness in the instant case. That would be inconsistent with Taj. And so in circumstances where my learned friend does not and indeed cannot rely on the terms of the policy because of the way the case was pleaded below, the policy cannot assist him. It is, however, relevant in a respect that assists the Secretary of State on a minor point, but one I do deal with. My learned friend argued that the reference in the interview and in the decision letters to a business plan was somehow indicative of the entrepreneur route being in the mind of the decision makers rather than Appendix ROB. But that is inconsistent with the terms of page 21 of the policy. Where you will note the third bullet point identifies as relevant, indeed a factor that must be considered, the employer's business plans.
Sorry, where are you?
This is page 21 of the policy document. Yep. Third bullet point, just above the heading employment status, third bullet point down. It's the loose document that I think my learned friend handed up earlier.
I think I'm looking at the wrong document.
Page 21 of 44.
Yes.
Page 21.
I may be looking at the wrong policy document.
I wonder if the page numbers have changed. The document you're looking at has a heading on it, does it?
It does,
The
but
page
I'm
does.
sorry, I'm looking at the wrong version. Let me just make sure I haven't misled the tribunal. The court by referring to something that's not in the right version.
Could be page 23 of this document.
I'm very grateful, my Lord. Forgive me. In my efforts to find the right policy, I downloaded a number of versions to confuse myself. But mercifully, they're as materially identical. So on page 23 of the right version, you'll see the text: to assess whether the applicant is an employee with the appropriate level of seniority and authority, you must consider bullet 3 employers' business plans. That's what question 5 in the interview, my submission, was plainly about. And the fact that that question and other questions are framed in a sort of colloquial way by referring to your business is nothing to the point. It's clear in context what the interviewer was asking about. It was the business that this overseas representative was coming to the UK in order to carry on in the UK. It wasn't her business, it was the business of the overseas business.
The guidance does seem to understand that the rule, where it coheres with your submissions, have authority to take business decisions on behalf of the overseas business to establish and operate a registered branch for one of the specifically.
Indeed, indeed. I mean, to be
I mean,
clear,
obviously that's not relevant to the construction rule, but
which is why we haven't focused on
no,
the policy, but since my learned friend will refer to it, I thought I should just draw attention to that part.
so that might explain why a question about business plans is asked, because it's something that the guidance talks about.
Yes, well, that's the point I'm making
Yes.
in response to my own friend's specific point about business plans being mentioned. And of course, maybe we do entirely endorse the suggestion that's been made that what I call the third element of ROB 8.2, forgive me, ROB 8.2, that refers to authority, does strongly support our construction of ROB 8.2.
Because there's no point having authority to do things unless it's you've got the authority so that you can do them.
Unless the things you have authority to do matter.
Yeah.
Finally, to draw this to a close, just on the interview, it's with respect putting things far too highly for my own friend to claim that the answers in interview are perfect answers. The reality is that the decision maker was perfectly entitled by Wednesbury principles to find fault with the answers in the way that the decision letter explained. I'll resist the temptation to go through some of the questions my learned friend referred to in the interest of time. The overarching point is that there's just nothing unfair in the way the questions were asked or inconsistent with the decision maker applying the correct rules.
Just as a matter, I mean, this may be completely and utterly irrelevant. But question 20, the thing about the time difference, is there a different time difference between the UK and Germany and France as regards the time zone that Bangladesh is in?
There must be nothing. There must be 1 hour time.
I think it's a 1 hour.
Oh, it's just 1 hour because of us being on the level we are, British summertime.
They like saving time.
Yeah.
I think that's the point. But in any event, I mean, my learned friend and the Upper Tribunal suggest there's some lack of clarity there. There wasn't, in my respectful submission. The first respondent was being asked about the geographical location of the United Kingdom, which was a natural question given that the business she wanted to represent was exporting things to Europe. And she gave an incorrect answer in terms of that geographical point. The decision maker was rationally entitled to rely on that.
Yes, I mean, I suppose the suggestion is that the answer was a sort of metaphorical answer, nearer to Bangladesh culturally or whatever. But your point is the decision maker is perfectly entitled to give it a literal.
I mean, the time bit has to be literal, but I can see that the word nearer is more open to interpretation.
With great respect to my own friend, this has the feel of an ex post facto rationalisation. but the right legal point is my lady's, that the decision maker was rationally and reasonably entitled to give the interpretation that was given to this text. I'd also point out that at the end of the interview, the first respondent was given the opportunity to say anything further if she could have clarified matters at that stage. That also happens in TACH. I have other points I can make, but I'm conscious of the time, and I think I've said more than enough. My lady, my lords, unless you have any questions, those are my submissions.
No, thank you very much. So, thank you very much, both of you, for very clear and to the point submissions. There's one loose end, which is the application form that could be sent through.
Yes.
One very minor gripe for future reference: the authorities bundle has the authorities beginning with the most recent and working backwards. If those compiling authorities bundles in the future could do it the other way round, that would be easier. At any rate, as you will have gathered, we're not going to give judgment here and now. You will be supplied with the judgment in draft in the normal way for you to correct our English and typing, but obviously not so as to re-argue the case. And we would be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we have brief written submissions? And we would expect to settle the points in the order that we make. And finally, though I know you will all be very well aware of this, the embargo will attach the draft judgment, and very considerable importance is attached to compliance with the embargo. If you think of anyone extra who ought to see the judgment before it's handed down, you obviously need to come back to us. Otherwise, the embargo will be breached.
I'm so sorry. So far as the application is concerned, do you require only the application form or everything that was submitted with the application?
I imagine in the application form. I don't know what form it takes, I'm afraid. I assume that there is a body of an application form and then potentially annexes to it.
Yes.
And I would think you just need to see the body of the form, unless... No?
It's just...
If there were loads of attachments, I think it might help us to know what the attachments
Yes,
are.
I mean, for example, there was an affidavit from the applicant. There
Yes.
was a
There's
cover
very-
letter, and
covering letter, yeah,
there are
I
50
think-
other documents. But if you want, we can provide you everything that was
Yeah.
submitted. The application form itself won't tell you much.
I see, yes.
But it's just that the other documents were not, I think, before the Upper Tribunal, and you may end up,
I don't mean to interrupt. That's just the slight concern we would have. That the parties agreed a hearing bundle containing the material that we thought the tribunal should see, and I would just be slightly concerned that if a lot of new material coming in at this stage, there's a danger that the court might be effectively looking at things that the Upper Tribunal didn't look at and couldn't look at, and that might cause difficulty. But of course, I'm in the court's hands.
I think we're backtracking. So we'll save you the bother of supplying the application form.
Thank you.
But thank you both very much.
Court rise approval?